Suppose your spouse died leaving everything to you in a will. Do you have to probate that will? Well, the answer is it depends. It specifically depends on the type of assets that are in that spouse's estate. You see, many of those assets are likely owned jointly already as joint tenants with rights of survivorship, or perhaps are left with naming the spouse as the pay-on-death beneficiary. In such circumstances, there's absolutely no reason to probate that will because the assets are actually passing outside of the probate estate. However, if there are assets that are solely in the name of that spouse, there's really no way to legally transfer title to those assets other than through probating that will. The probate process will actually declare that will to be valid, notify all of the parties that are entitled to notification, and then ultimately have a judicial declaration after creditors are notified, declaring those assets to be owned now by that spouse pursuant to the declaration inside of that will. But if they're owned specifically by the spouse, the only way to get legal title perfected in the name of that spouse is going to be through the probate process and probating that will.